Get underway, thank you. So this is now day 4 of the Stream 11 hearing. We have the Horokiwi Quarries team, number 1 to go. Welcome, team. Okay, welcome, Dr. Keesing, the first time, I think. So, Ms. Whitney, how do you wish to proceed?
Thank you. Good morning. I just thought I have provided some speaking notes, which I thought would be beneficial. It's quite echoey. Is it just me? Yes, it's okay. Sounds like yeah. So I did provide some speaking notes, 6 pages, and it takes me 6 minutes to read through them, if that's okay, so bear with me. I just thought it would be helpful if you had them prior, so I could.
I think that since the ecological issues, primarily the issue, the subject of Dr. Keesing's evidence, are no longer in contention, I think we've gained some hearing time. That's not to say he's completely off the hook. We'll see if we have any interesting issues to explore with him. So yes, please take us through it slowly. I have read your speaking notes, but I'm not sure my colleagues have. So go through it slowly because it's quite, I was going to say dense, but that's not intended.
No, I understand.
It's intended as a criticism.
It's not a think piece, but yeah, no. So just to confirm as well, Dr. Keesing's comfortable with obviously the rebuttal evidence of Mr. Goldwater.
Unsurprisingly.
So yeah, so no other comments on that. And there's been nothing that has come up at the hearing that changes his position. So just to confirm that. So obviously Dr. Keesing's here as well, just if the panel has any questions or any wider questions that they may like to put to him. And obviously Mr. Baker's here. Mr. Baker provided evidence in hearing 4, 5, I think. So that still stands.
And 6.
So available to just answer any operational quarry questions the panel may have.
Okay, thank you.
So obviously, just for the record, my name's Pauline Whitney. I'm a playwright from school. So I think this is maybe my 5th hearing here or 4th with Horokiwi. So there were 3 general and 2 key issues raised in my evidence. Oh, and just confirmed I did listen to the majority of the hearing over the past 2.5 days in the background. So I'm aware of some of the questions that were put and discussed. And also I have read the speaking notes of Greater Wellington and reviewed the legal submissions of Forest and Bird. So there was only really one matter of Forest and Bird's legal subs that I've commented on at the end of my speaking notes. So if I can just maybe run through the 3 general issues first, and then I'll go to the 2 specific quarry issues, if that's agreeable. So at 1.4, the first general issue was the appropriateness of including general IB provisions outside SNAs through the hearing process. So the issue has obviously been well canvassed at the hearing, and having listened to the discussion, my concerns have not been alleviated. I fully understand and appreciate the gap created by the council decision to not notify SNAs within urban areas. However, creating a whole new regime for the entire city, not just urban areas, that have not been subject to sufficient evaluation and testing, in my opinion, fails to convince me they are the most efficient and effective method. I have got efficient there twice, one should be effective. I too was disappointed as to the lack of evidence presented on the recommendations, but I suggest this reflects that many parties did not have scope or even aware of the recommendations, given they were not signalled at all and the PDP is notified. So this is a different issue than the SNAs within urban areas not being included, which was clearly signalled in the Forest and Bird submission. So the issues to be addressed in 3.16 of the NPSIB are different from that of SNAs. So I guess my general position, I would support a plan change or variation to give effect to the NPSIB, including clause 3.16. So general issue 2, paragraph 1.5, my concerns remain with the use of the word minimise within Echo P8. While I accept clause 1 of Echo P8 and that it gives effect to the NPSIB, given the MPSIB requires that such effects be managed in relation to clause 2. So this is effects which are not significant. So the MPSIB requires they be managed. I'm not convinced why effects that are not significant should be minimised as recommended in policy ECO P8. I guess this concern is elevated as the clear lack of evidential basis in testing for the 100 metre square threshold for urban areas. The lack of support in policy direction or clarity as to what are the significant effects associated with this clearance further compounds the difficulty with the policy as recommended. So I guess I just have concerns about how the policy would be interpreted and applied at a consenting level. I did hear a suggestion yesterday, I think it was yesterday or maybe the day before, as to the potential use of terms reduce or lessen or appropriately mitigate. I guess my underlying concerns remain, without any wider policy support or knowledge about the values, what actual effects will Council be seeking to reduce or lessen or mitigate? Is it the amount of clearance, the certain types of vegetation, the threatened or at-risk status, or vegetation of a certain age? If the overall objective is to maintain Indigenous biodiversity generally, as required by the MPSIB, how would this be evaluated on a site-specific basis? Or would it be at a citywide basis? And I just had another look through the objectives that are recommended, and I note ECO 01 requires to maintain Indigenous biodiversity so there's no overall loss at a citywide level. So I've included that objective at the bottom of page 1 as a footnote. So arguably ECO P8 as drafted does not reflect the recommended objective. So I am cognizant that no material, either evidence or statement, has been provided to the panel on the Greater Wellington Regional Council RPS Plan Change 1. Having been involved with the process as a submitter and a party to the joint witness statement on Indigenous biodiversity, I am aware provisions have significantly changed through the hearings process. There's now a proposed policy IE2A, and that was recommended through the hearing process. And that uses the word manage. This applies to Indigenous biodiversity outside SNAs. So it's a general policy for IB at a general level. So that recommended policy uses the word manage, and reference in clause C in relation to effects that are not significant refers to no overall loss within the region or district as applicable. So it almost refers a citywide approach. So such a policy directive could be applied at a citywide level as opposed to a rule and untested area limit, which is applied at a site level. And I appreciate that is still up in the air, and I suspect it will be appealed. So it may be some time before it lands. But I guess the key things out of that is it does use the word manage, and it infers a higher level approach rather than the site-specific approach that has been recommended through this hearing process. So general issue 3, when is a tree? I must admit I did find the explanation provided by Mr. Goldwater as to how he would define, identify a tree quite complicated. And the explanation kind of increased my concerns as to the workability of the condition. Now, I have considered the definition proffered by Mr. McCutcheon to adopt the definition in the Lower Hutt City Plan. So without specific wording, I presume the intent is that trees under 3 metres in height or less than 300 millimetre diameter at breast height, which I understand to be 1.3 metres from ground level, would be permitted. So certainly for a layperson, I think that's a pragmatic and workable approach. However, I guess I still have some queries about what are the effects of allowing removal of smaller trees on the maintenance of Indigenous biodiversity, and what are the effects of such tree removal on the calculation of contiguous area in clause C. So if you can take out those trees, and it affects the contiguous area, what does that mean for the calculation? I can see a lot of discussion occurring at the consenting stage. And given it's a permitted activity threshold, it is quite significant. So, and I certainly would have concerns if residents had to engage ecological advice to argue or define the point.
Wouldn't they just need a tape measure?
It is, but it also then about the contiguous area and things like that. So, yeah. So again, without being wishing to be repetitive, I think given the implications of a definition in the rule, I do question the appropriateness of introducing it through the hearings process. So key issue 1, changed the boundary extent of SNA WC 109. That's no longer in contention, I understand. Key issue 2, the officer recommended quarry provisions. So this is a bit of detail here. So in my evidence, I saw recognition of quarries within Eco P7 and amendment to the rule thresholds within Eco S2 for quarry activities. And I just note that no other planning evidence has been lodged on these provisions. I guess my in terms of the I'll first just briefly respond very quickly to the legal submissions from Forest and Bird seeking exclusion of expansion with Eco R13A. And I heard some discussion on yesterday, about clarifying this would apply to a new quarry. So I'd accept such an approach should the word expansion be included. So then just moving on to Eco P7. So that policy relates to appropriate trimming, pruning or vegetation removal in significant natural areas. So I'm comfortable with that policy. My only query is that there's no equivalent policy for Indigenous biodiversity trimming, removal or pruning outside significant natural areas. So I guess that was my concern, that I saw a bit of a policy gap there. You have got Eco P8, but that's kind of managing the effects, not recognising some of those activities. So I guess the officer rebuttal changes does not address my concerns. And while I fully agree the NPSIB does not have a more defined policy framework for areas outside an SNA, it does recognise the benefits of certain activities as provided in NPS Policy 10. And even Policy Provision 315 of the NPSIB does refer to, certain activities and providing policies and rules to recognise those specified activities, which are not defined. So I think the NPSIB gives enough direction that there should be some policy support for IB outside SNAs for those permitted activities. Then just turning to paragraph 1.12 in relation to the Eco Standard 2. So I've read the rebuttal evidence of Mr McCutcheon's. My concerns remain. While Mr McCutcheon has recommended a change to Eco S2 and S3 to move the standard to S3, I think it's just a drafting area, but this will not work in practice as S3 is confined to the general rural zone. So I guess that could probably easily be remedied, making it also the quarry zone in there. But I guess that just doesn't address the underlying concern as to the workability of that 5 metres as well. Apologise, I've probably jumped around here. My thought process yesterday I was doing this. So maybe if I just move to paragraph 1.14 and then I can come back to 1.13 if that's okay. So 1.14 is kind of a continuation of that 2.5 metres, 5 metres, or the 3,000 that I sought in my evidence for the quarry site as the permitted threshold within an SNA. So as I've outlined in paragraph 1.14, notwithstanding the location of the standard, I do not think a 2.5 or 5 metre width for an access track sufficient to allow for the operation and maintenance of the quarry. To assist the panel, below is a very simplistic map showing the existing zoned quarry site in areas of SNA. So I've not included, so I've just done the existing quarry site as zoned in the PDP, and I haven't included any areas for the areas fronting State Highway, given I fully acknowledge there's probably issues with developing those. So I've really just concentrated on areas which are part of the kind of quarry operation at the moment. So in particular, those areas to the north, I've done an area of 3,707 metres squared, the area below that. So these are the areas I calculated the area of SNA within the quarry zone, within that wedge. So you see they range from 1,070 to 6,090 approximately. So in terms of that top area, I understand Horokiwi is currently exploring options within the northern portion in those SNAs to potentially place overburden associated with the existing operation. So there are activities going on within potential SNA areas that are part of the existing quarry operation. And obviously for any new areas that may be zoned through this process, quarry zone, that 3,000 still sets a threshold if we were going to go across Horokiwi Road and things like that. So then the final point in my evidence is just a minor one. I just picked up in paragraph 1.113, I just picked up another drafting anomaly, well I think it is, in Eco Rule R4.2. That clause D is not confined to a site. So I know clause, I've just highlighted very simply there, the two clauses. So C refers to site, but D, but they're not conjunctive, those two clauses, but D has no such reference to site. So I don't know if, yeah, it may not matter, given, are there any thresholds? I must admit, when I look at these rules, I find something new every time, but that's just me working my way through them. I guess they're quite general, so there's no actual area limits in there. So maybe the word site's not needed, but it's just something to look at. So thank you, and obviously Dr. Keesing and myself welcome any questions.
My first question of Dr. Keesing is, what's your definition of a tree?
The definition is a little bit nefarious, but basically you've got to have bark. So you've got to have a secondary cambium thickening to be a tree. But then a tree is a word to describe a structure. So you have a grass and you have a herb and you have a tree. So tree is about structure. So it must have wood, secondary thickening, and it must have a particular height. Otherwise it's a sapling or it's a shrub. So a tree in the literature overseas is 5 metres or more. In other places in Europe, sometimes it's 4.5 metres and more. The height is a little bit arbitrary, but it also needs to have a main stem, which normally has a particular diameter or size. So a tree is about size. You need to have a certain height, you need to have a certain thickness of it, and it needs to be wood. Wood, height, thickness, main stem. Although, keep in mind, purukawas don't look like they've got main stems, and they're trees. Cabbage trees don't have secondary thickening, but they're trees. So it's more height and thickness, and wood is almost a secondary, even though in ecological terms, wood is the first thing. But I think from a plan point of view, and what we're trying to do about not remove trees perhaps, is about height and thickness and then wood. Otherwise you'd be chopping down cabbage trees left, right and centre because they don't have wood.
So you say a cabbage tree doesn't have bark, or doesn't have wood?
It doesn't have wood. The tissue inside of it that's holding it up is not wood. So it's not about bark, it's about wood. But From our perspective, you know, most people see bark and go, oh, that's a woody thing, right? Not necessarily, but it should have wood. It should have a height that is at least, I would suggest, 4 meters, and then a size. And I think the 300 millimeter that's used in, was it KCDC? So Porirua.
Oh, the lower hut.
The lower hut, sorry.
Yeah.
That's fine. But as I say, other literature around the world treats trees as being 4 or 5 meters higher. 3 seems a little low, but it's kind of arbitrary.
And the interesting thing is that the way it applies is that you can't have rules that apply to trees unless they're individually identified or they're in an SNA. So that it's sort of counterintuitive, because as Ms. Whitney points out, like if you have a cutoff, so the big things, the big woody things are excluded. The smaller woody things that might become big given half a chance,
Yes,
are not excluded, and they're covered, which might produce, well, that's your regeneration potential. Mr. Dash, did you have any questions of Dr. Keesing, or general questions?
I don't know whether you've been following this hearing in any detail.
some, because I get insights.
Yeah. So I guess we've got two fairly contrasting positions from a policy perspective. Obviously, on one hand, people don't want to have any restrictions on private property. And you know, historically in Wellington, vegetation removal was pretty much permitted unless there was an individual tree or it was in a conservation site or something like that. And then we get the NPSIB and the allocation of significant natural areas within Wellington City. And the NPSIB does two things. It obviously talks about SNAs, but it also talks about areas outside of SNAs. And there's been quite a lot of contrasting positions about issues of natural justice, which as Whitney's referred to, but there's also been some ecological evidence from wildlands itself, which is saying, well, it is all part of the Indigenous biodiversity big picture, if you like. There's also been some questions about the actual identification of SNAs themselves and the criteria that have been used using the RPS criteria and the level of work that has actually been done to specify that they actually have the Indigenous biodiversity values which have been specified. If you were starting the process yourself or managing the process yourself and talking about the identification of SNAs, do you think there's been significant rigour that has gone in to identify both the locations and the spatial extents of those? Because I understand that the process primarily has been done on the basis of aerial imagery. And only when there is a specific question has there been an ecologist go in and with their boots on and actually have a bit of a poke around and see what is actually there. Because SNAs have, you know, there's significant weight and there's a whole bunch of rules and a whole bunch of development restrictions potentially in and around them. Do you feel that there's been significant preparatory work done in terms of identification of those SNAs in a general sense?
Not at all. No, and despite the fact that the criteria, be it in the policy 23 or as amended or in the NPSIB, being quite encompassing, inclusive, you still must have boots on the ground to determine most of these criteria. Otherwise, you're making large assumptions looking at the aerials. And I know, because I've had a number of clients, or Boffin School, I've had a number of clients earlier who have asked, you know, for boots on the ground assessments, and you've gone and you've actually found that it didn't have the integrity it needed to do, or it had mostly exotic species under a loose cover of a couple of natives. And so it didn't reasonably meet a lot of these things. And you can't do that with fidelity from the air, and you can't do that from a distance with binoculars. And while there is a lot of area to cover, and a lot of these features are semi-connected or quite well connected or loosely connected, you can't make assumptions of one against the wider picture. You need to go through it all, I think.
Mm.
And if you were to go through these criteria with some high level of fidelity, which I think is required to be accurate, you'd have to go to all of these places to make those assessments.
And in terms of the criteria itself, and we are, if you like, in a bit of a state of flux with the RPS and the existing policy 23, policy 24. We don't have decisions on those. They're not due out till the end of the year. But in terms of those criteria itself, and intuitively, and it only be my initial take, it seems relatively easy to qualify for
It's very, as I said,
for,
they're very
for
inclusive.
to be
Yeah.
If you have one rare species, for example, it will qualify.
Yep.
Or if you have examples of birds roosting in a particular area, which either have some threatened classification or more, then it would qualify. But there's also large patches of vegetation which are representative as well, so it could meet that criteria. So is the bar too high for qualification for an SNA? And thinking about the Wellington context.
Yeah, do you mean too low? Is it
No,
too easy?
well, yes, too
to
easy.
be-
Sorry.
I think it's far too easy in the Wellington context to be called an SNA, because a lot of those criteria are subjective, and a lot of those criteria work through the ecological context component of that, which is very broad: buffering, corridors, connectivity. Almost no evidence exists about what native animals need from a connectivity point of view. So it's very easy to say, in a precautionary fashion, that probably facilitates something going between that bit and that bit. Connectivity met, tick the context box, it's significant. And so even the NPSIB set of criteria, which are better because they try to explain more about how you should run the criteria, still allow a very positive approach to making everything SNA. So both sets of criteria are very easy on minimal information to meet one of those criteria, and some of those criteria can't be factually proven.
Were you involved in the hearings on Plan Change 1, RPS Plan Change 1 at all?
I think I was, yes.
Okay, and presumably you were able to share those same observations about the criteria at those hearings?
Yes.
Okay, so well, that is useful to us, because there are a large number of SNAs which are unchallenged, but there are others which may have implications either on rural land, and we heard from people in rural areas that have both a philosophical position, but they also have a practical position that's going to affect their farming operations potentially. And then on the other hand, we have the views of Forest and Bird, for example, who basically say, well, New Zealand's in a indigenous biodiversity crisis of some kind, and therefore we must need to do more. We're in the position of needing to work out a set of rules here, which need to thread the needle. I think has been used many times in these hearings already, to actually be able to do something. We're also in the position where in the urban areas, these submissions wanting to put the urban SNAs back in, where it comes headlong against the National Policy Statement for Urban Development and what you can do as of right. So the question is, I'm really looking for some guidance from the ecological perspective about how we get that sweet spot, because the NPSIB is telling us we must do something. But what is that something? Have you got any pearls of wisdom for us?
I don't know if they're pearls. 35 years in, and what I've found is that typically the only way that you get biodiversity gains through removal of predation, through protection of areas, through enhancement, through planting, is money, and you need to allow something to happen to get that access to that money you give to get. Otherwise, the prohibitive lock it up but don't put any resources into it, and we all agree to this, leads to the degradation of that area, especially when they're small areas. Large areas sustain themselves better than small areas. Small areas that we currently call SNAs in the rural landscape, and certainly in the urban, are often shouldn't be SNAs. They're not significant, but they have remnant Indigenous biodiversity, normally in some form of decline, either because there's no new regeneration, because they've been grazed, and or the fauna are being eaten out by rats, cats and possums and whatnots. If nobody throws any money to protect those processes and stop those processes, all of those features will be gone. No question about it, they will be gone. But we still label them and point at them and say those are SNAs, and lock them up. We draw a line on the map, and the map line doesn't protect them at all from the current destruction. The only things that can protect them are physical things that need money. And the only way you get money is to say, well, here's a consent process, and you need to fix manage that. And you can knock that down, but protect that. In my experience, that is the most useful way to get biodiversity gain. Not to protect, but to allow to get.
Yeah. We also heard some evidence that in terms of Wellington City, there's actually been an improvement in terms of overall big picture Indigenous biodiversity.
Correct.
And we had heard that a lot of that surrounds Zealandia and what that does on the outside.
Yep.
But also Wellington has a pretty large outer town belt as well now, which has been progressively added to over the years.
Post-war. So post-war, a lot of land ceased to be farmed. And we had a mass gorse regeneration across the hills, and that's turned into a mass Mahoe forest complex. And so due to changing land uses through those post-war periods, from 1980s to 1990s, that regeneration has now closed a lot of the hills. So that has been a general increase. A lot of the value in that Mahoe isn't necessarily there, but it looks like it is. And so when you wander into it, some bits still have the fauna you would expect. Some people, you still have some ground tier and ferns and all that kind of stuff. But in some areas, it's simply grazed under by deer and goats and pigs, and it's not so good. But nominally, there has been an improvement in the amount of Indigenous vegetation across the Wellington.
So talking about threading the needle again, you're talking about wanting to achieve overall improvements to Indigenous biodiversity. There's a lot of stuff happening at
You've got to protect the big things that have the potential to carry on.
Sure. But if there is a removal of 200 square metres of bush on a residentially zoned site,
that makes no difference.
At a local level,
yeah.
It might have some effect on the local Indigenous biodiversity in that area.
No, keep in mind your garden probably has as much Indigenous biodiversity value to fauna and plants as that piece of possibly unmanaged Indigenous. So in Wadestown, my garden, I have at least 3 at-risk species living in my garden, and I have quite an array of Indigenous plants. Maybe that's my fault because I'm an ecologist, and I planted them, but a lot of people in here do that. The native trees provide some of the most important resources for the tui and kaka flying around. So there's this mix and belief that our modified indigenous forests, which are now gardens that have a mixture of exotics, they're almost as valuable to a range of species as a small area of mahaui with a rewa who were in it. That might be, 10 meters by 10 meters or 10 meters by 20 meters to 200 squares.
So I take it in that respect, you have some problems with the NPSIB,
I do.
but it is what it is,
It is.
certainly in its current form.
Mm.
And so therefore the council was actually directed to do something about areas of indigenous biodiversity outside of significant natural areas.
Well, yes, 316, I think it is, isn't it?
Yeah.
Yeah.
And that could be, and the range of options that are being put to us are really, you got to do something. And what is the square meter areage of that would try and, again, using this terrible term, thread the needle through this particular process, whether it should be 100 or 200 or 300.
Well,
I guess these are
for you there.
Pardon?
For you there then.
Good.
It's generally accepted that from a viability point of view, a piece of forest or bush to not be edge effect and have a core needs to be 9 hectares or greater, right? That's in the literature. But it's generally accepted that from about half a hectare onwards, a feature can have some form of integrity if it's managed. And below that, it tends to be all edge and without integrity. And while an area, and let's imagine your 200 square meter thing might have 7 trees in it, the value of that ecologically is really limited. And it's limited mostly to if that area has a resource feature, like a big kofi that flowers, and everybody comes there for 2 days of a year. Other than that, it doesn't supply much functionally or ecologically to the wider range any more than the garden plant does.
That would suggest to me that the focus shouldn't be on how much is taken, but how much is left.
Yeah. And 316 does say, you can effects manage it. And I think that's really possible in the rural landscape where you have space, and really difficult in the urban where you don't have space. And you can't say to that person over there at that house who has a little piece of the non-SNA that's, 7 trees and 200 meters squared, you have to offset that, because how do they do that?
Yeah, no, and that point's been made before.
But
on a larger scale, we potentially got access to more land.
It's doable.
It's doable, but on a smaller scale, an individual property owner,
unless the Wellington City said, here is this area we own, which is SNA, and it's got problems, all of you can contribute to that through your offset. Here you go, here you go, here you go. Now we've got a viable managed feature.
Yeah, well, and that, I don't know if that option has really been put on the table to us in any form that we can understand as being something. We did talk to Mr. McCutcheon in a little bit of detail about what potential non-statutory methods there might be, which are very much promote, encourage and so forth. But there is also, as you mentioned, there is potential, and again, we don't have it in front of us, to look at things like financial contributions, the old reserves contributions, in lieu of actually providing for a reserve. You give some money to go towards a common reserve entitlement. So a similar sort of process could be investigated.
Because I think what you have to remember, and what the MPS doesn't make clear, is surface area or coverage isn't the same as quality. And you can have all the surface area of crap you like, and it's crap. And if you must have quality. Otherwise, you're not really securing indigenous biodiversity.
So you think it's the 100, 200, 300, whatever it may be, is too blunt a tool?
Yep.
And for those areas, it presumably depends in terms of the quality of indigenous biodiversity, whether it abuts other areas which are have a similar composition.
Yep, supplies an important resource that isn't otherwise found in the landscape,
Yeah, okay.
But keep in mind, it wasn't SNA.
Yes.
You know, so it doesn't have those values necessarily. Otherwise, that would have been recognised under context or representativeness or rarity or something.
But even if it was an SNA, you consider that there possibly hasn't been enough work done
Oh, yes.
to specifically
Identify the value.
identify the values in terms of, is in your words, where the bar is and how easy it is to get over or under the bar.
Yeah.
Okay, that's very useful. Thank you.
I wonder if we should turn to the planning issues since I'm looking at the clock. Fascinating though that is. Ms. Whitney, you've highlighted in your evidence and again in your summary the provisions for areas outside SNAs and said, well, they say manage, they don't say minimise.
Mm.
They also say manage to give effect to the objective and policies of this national policy statement. And so what gives effect to this national policy statement? What level of management intervention, and both the level and nature?
I'm not quite clear on the question, but I will have an.
Well, as I say, I've just come to me, but as I say, you say you've emphasised the word managed.
Yes.
And consistently to planners who have come before this panel and said, shift something to say managed or mitigated. I've asked the next question, which is managed or mitigated to what end? To what result? Because otherwise it's sort of, to me, it's meaningless. It provides no direction. So in this case, the NPS says managed to give effect to the objectives and policies of the NPSIB. What do the objectives and policies of the NPSIB require in relation to Indigenous biodiversity outside SNAs, or just generally?
It's generally, I guess it's objective 1A, to maintain IB across Aotearoa, New Zealand. So there's no overall, at least no overall loss in IB. So that applies within and outside SNAs. So I guess the word manage and then maintain is a common word that's also used through the NPSIB that I observe. And that there's obviously different mechanisms for achieving that.
And that's a nice segue into the next question, which is you've drawn attention to the where the change one appears to have landed, yet to be confirmed, saying no overall loss between the regional districts as applicable. How do you get from that kind of direction, which is the same direction as Mr. McCutcheon is recommending, no overall loss within the Wellington City, so they're consistent? How do you get from that to what actually happens on an individual site? How do you know, how do you manage a proposal on an individual site so that you know whether it will or will not allow and no overall loss across the city?
Agree, it's tricky. And that's why I think, to my knowledge, I'm not aware of other plans which have introduced a broad IB rule or policy outside SNAs, where SNAs have been identified. Fully accept where there's no SNAs identified, a rule has been provided. But where SNAs have been identified and ground truthed, and quite a lot of rigour have gone into them to identify them, I'm not aware of other plans which have a general IB. So to my mind, it's new ground. And I guess my concern is through this hearing process, we're rushing into it without the proper evaluation and the information. And I think, I fully accept 316 of the NPSIB and what it directs. But there's different ways to achieve that, and I think it has to be really informed by good knowledge and an understanding of what the issue you're trying to address is, and then the framework to achieve that, so it's clear. I think, as I highlighted, I mean, I don't even know what, as Dr. Keesing's kind of talked about, what are the values we're wanting to maintain? Is it just IB for IB's sake? And is that effective or efficient?
Well, that then gets back to the point that Commissioner Dash was asking and saying, well, whatever you think about the merits of the NPSIB, it is what it is, and we're directed to give effect to it unless and until it changes.
Agree, but it also has to be a robust process. And there will be a plan change required to give effect to other parts of the NPSIB. You know, I mean, as I think I pointed out, you know, there's no reference to policy 10 of the NPSIB, activities that contribute to New Zealand's social, economic, cultural and environment wellbeing are recognised. You know, so I think the whole package isn't there, and that's been accepted by everybody, I think, and pointed out. So I guess my position is IB generally, let's do it as part of the follow-up variational plan change. And we'll probably have some greater guidance from the RPS hopefully then as well.
Others have described that approach as kicking the can down the road. And so the question is, can we be confident that in that hiatus period, while everybody gazes at their navels and tries to sort out these tricky questions and come up with a robust methodology to do that, you won't get a significant, well, in effect, a U-turn in the Wellington context, a U-turn from a process of improving biodiversity as everybody leaps in and think, well, I better clear it until I'm, in case I'm constrained from clearing it in future.
I mean, yeah, you have got significant areas identified in the Royal Zone as SNAs, and I think certainly from my observations as a planner comparing it to other regions, they are very, very extensive and haven't been ground truthed. Other than when raised as part of this process. So there is that level of protection at citywide level at the moment through those SNA rules which have legal effect as notified in the SNA areas. So, I mean, I think we fully accept there's a gap in the urban areas. It is what it is, but I just don't support giving effect to clause 316 through this process to address that gap when it's trying to address a different issue, and the issue hasn't been clearly articulated, that IB isn't being maintained through Wellington.
So you're saying, well, even if all of the IB in the urban area were flattened on private IB, there would, as a proportion of IB across the city,
Tiny.
it's quite small.
It's small.
And you still have obviously rules in the Natural Resources Plan. There's the 3,000 for earthworks standard, which sets a threshold as well and some level of protection. I think that's a discretionary activity from memory. I cannot remember, sorry, the activity status, but what that would then allow the Regional Council to consider in those earthworks. And obviously the NPSIB would then come into play because it's a higher order instrument.
We talk about the issue of direct interest. Well, it's quarter team. We can finally talk about Mr. Baker's issues.
Yes.
Rather than solving the problems of the rest of the
I did point that out to Mr. Baker, but yeah.
The provisions are about what the question that I'm trying to get at is what is the continued operation of a quarry, because
Mm.
my lay impression, if there's an area of natural indigenous biodiversity on quarry site, it's because it hasn't, or use of that land that indigenous biodiversity is sitting on is not part of the existing operation of the quarry, and that if there is a proposal to flatten it for whatever reason, that would be, it could be because of access from one part of the quarry to another. But the alternative is that it's actually an extension to the quarry, that previously the lip of the hole was here and you want to shift it to here. And the space between has indigenous biodiversity on it. And the query is, like, my impression is that's an extension. It's not existing operation. But the question, the question for you is, do you agree with that? That characterization, and if not, why not?
I probably don't. And again, it's so site specific. And I think that map, then the plan on page 5, my speaking notes, I think is quite helpful. Because it does show in purple the SNAs on the quarry site, taking the quarry site as notified. So those areas at the top, that 3,707 metre square area, Mr. Baker might be able to clarify, but I understand that is part of the quarry. Was that formerly a stormwater, or have you done work in there in the past and it's regenerated?
Yeah, we did a that was actually part of a land swap that we did with Right Way Homes. They took a part and did that, so it has been worked.
Has been worked, and as it growing back is
Yes.
vegetation. So it is an ongoing iterative process in terms of the operation, and I think the plan is to use that as overburden. So it may not be quarried as such, but it's part of the quarry operation in terms of wider activities.
Is that the key question? Like in terms of policy guidance that I asked Mr. Anderson yesterday, because his suggestion was put in the rule, but not extension.
Mm.
And I said, well, would it be better, rather than saying what the rule doesn't do, to have an advice note as to what's in which rule and what is an extension?
Mm.
So I think the answer I'm getting from you is that if it's previously been used for quarry purposes, for quarrying, the fact that it's regenerated is neither here nor there. It's still part of the ongoing the continuous operation. But if it hasn't previously been used, that would be an extension. Is that? Am I getting that correct?
I would have to. I'd want to know. Go through those areas and know actually what's going on.
But I'm contemplating an advice note that says that an extension of quarrying to an area that has not been previously been used for quarrying purposes is under the new quarry rules, whereas a quote extension into an area previously used is not, is under the continuing operation, like as a concept. So what's your response?
I would have to see the drafting, honestly.
Uh,
I'm certainly open to the idea, but again, I guess it comes back. I don't wish to repeat myself, but like drafting stuff at this late stage at a hearing. It's not
Well-
optimal, but I understand the predicament and I understand that it only affects Horokiwi and Kiwi Point as well, obviously. The rule will apply to them.
Okay, I have a proposition for you then.
Yes.
Rather than considering my drafting floated out of thin air,
Yeah.
you can have until Wednesday next week to give me your drafting that captures what is an extension and what is not, in order that Mr.
Mhm.
McCutcheon can then tell us what he thinks of it.
Certainly, we can provide something like that. Mhm.
And assume, put it in the form of an advice note that would sit in the rules.
Would that have, are you thinking about an area threshold or the 2.5 or 5 metre track component? Just so I can understand the context of,
Um,
because I guess if it's still a 2.5 metre or 5 metre track, then there's no point doing this advice note because it's not, yeah.
that at the moment, well, I'm open to that. Like, I'm not wedded to as we've discussed with, as you probably heard, we've discussed with Mr. McCutcheon, the fact of, well, is a width, in fact, the right measure? Because a width is only appropriate for a track.
Agree.
And so that, but that's the key point. The MPSIB directs us that
Mhm.
that continued office
Mm.
operation of quarries is an exception.
Mhm.
But the question is, what does continued operation mean? And that then, once we've got that figured out, we might figure out, well, how does the exception apply?
Agree.
So as I
Is all quarries expand?
Sorry, the end of Wednesday, is that?
yes,
Close of Wednesday, yes.
yes, you can crib another 4 hours if
Oh, sorry.
if that's
No, I can do
meaningful.
it lunchtime Wednesday.
So I think that was my questions, Mr. Dace. Did you have any more questions?
No, I don't think so. I think it's been a pretty good traverse, so I'll be interested in your additional wording and also be interested in Mr. McCutcheon's view and write a reply as well. So, thank you.
Go for it.
Just for clarification, that the easy fix for standard 2 was just to include the quarry zone, isn't it?
Yes, that's what I thought of this morning when I was mulling over it and thinking, is it a huge fatal flaw? And I don't think it is. I
Yeah.
think it could just be
Just
to
an
include
easy
the
fix.
quarry zone in there if the panel's wedded to that 5 metres. Yeah.
And the other question I just wanted, so in regard to Eco P8, in your evidence, you preferred avoid, remedy, mitigate.
Yes, yeah.
So are you, shall I say, ditching that and preferring?
Thanks for that question. Yes, after listening, yes, and reflecting, yeah, my preferred position. Yeah, I'm not comfortable with that now, having heard everything
Yeah.
and the queries about how the policy would be applied. I think avoid, remedy or mitigate is still quite onerous and could be problematic. Because
Sure.
again, it comes to what are you trying to avoid, remedy or mitigate, what values?
Yeah, so you prefer maintain,
Manage.
Manage if it's
Sorry.
going to be there. If it is,
Manage,
yeah,
yeah.
manage
Yeah,
be
yeah, yeah.
the, yeah. But
Okay.
again, I don't think it adds in, doesn't give the, from a plan application interpretation. What does it mean?
Yep, sure.
It's kicking the can.
Okay, thank you. That's all I had.
Mr. Primero?
Kia ora koutou. No further questions from me. It's been a very helpful discussion this
Thank you.
morning. So thank you very much for coming along.
One final point. If you were listening, you probably heard me saying that we're of course waiting for the change 1 decisions. We're also waiting for legislative change.
Mhm.
Well, we're not so much waiting, but it's going to arrive before we are in a position to write write up our recommendations. So we will have to take account of both. As regards specifically the change one decisions, my intention is to have a written go round when the decisions are in hand to ask Mr. McCutcheon for his view. How does this, where have the goalposts shifted to? How does this change his recommendations, if any? And then to invite the parties to this process to comment on his advice, and he will have the final right of reply. And we'll probably do the same for legislative change when and if it occurs. Although that might be more obvious, might not too, depending on what it says.
A query, is it confined to parties who have presented evidence to this hearing, or will you be
No.
putting that out to all submitters?
I think it's all submitters on the eco chapter,
Right,
as opposed to all submitters, period.
yes, okay, so
Uh,
even those who haven't provided evidence.
Correct, because they might have been perfect. They might not have provided evidence because they were perfectly happy with Mr. McCutcheon's previous recommendations and didn't feel the need to come and tell us that.
Thank you.
But that's my intention at the moment,
Okay.
and it will be in writing. And assuming the regional council stays on the timeframes, it's probably in September. Not in September. It's probably the second half of October.
I've heard the 4th of October is the date.
Yeah, I'm anticipating. Yeah, there'll be the decisions will be in the public domain. Mr. McCutcheon will need a fortnight to figure out what they all mean, and
Yes.
then parties can have another fortnight to tell us what they think it means.
Having seen, provisions through the right of replies and things like that, he will definitely need the 2 weeks. Yeah.
Well, yes, indeed. Mr. McCutcheon has based his recommendations on the right of reply,
Right.
so I'm anticipating the issues will be if it shifts from there,
Yes, yes,
and if so, how far and in what directions. However, that's just for your information.
thank you.
So
Yep.
it's in the be prepared category. So thank you very much all. I think that's all the questions we have.
Thank you. That's the last appearance by Horokiwi.
Touch wood. Well, I bet Mr. Baker's hoping that. Thank you.
Thank you.
Thank you very much. Our next speaker is Mr. Doherty. Mr. Doherty, you've given us a hearing statement, which we've read, so I don't want you to read it to us, but is there anything you particularly want to highlight in your statement to us? You have that opportunity now. Okay,
Related to
go for it.
my written submission. So, Commissioners, thank you for the opportunity to speak to you today. You have my written submission and I will speak to parts of that, but my verbal submission is focused on the broader aspects of giving effect to the NPSIB. My interpretation of the NPSIB and my submission is centred around no net loss of Indigenous biodiversity, with significant Indigenous vegetation being protected at the date of commencement around the area that I live. At the highest level, New Zealand has signed the UN Framework Convention on Climate Change, the Kyoto Protocol and the Paris Agreement. The Convention, the Protocol and the Agreement are now all incorporated into New Zealand law by the Climate Change Response Act, whose purpose is to provide a framework by which New Zealand can develop and implement clear and stable policies that enable New Zealand to meet its international obligations under the Convention, the Protocol and the Paris Agreement. Our free trade agreement with the United Kingdom commits New Zealand to implementing the Paris Agreement. There's a whole chapter dedicated to the environment where both parties agree to achieving the objectives of the Paris Agreement, reducing biodiversity loss and reducing deforestation from land use and land use change. New Zealand Government has given commitments to our Pacific neighbours that we will do our part in reducing greenhouse gas emissions to minimise the effects of sea level rise. In summary, at our highest levels of governance, New Zealand is committed to protecting its Indigenous forests as carbon sinks and reservoirs as part of the global effort to minimise the amount of carbon emissions we produce and limit the effects of climate change to 1.5 degrees of warming. Having made these binding commitments through the Climate Change Response Act, the Government has issued a directive via the NPSIB, whose objective is to maintain Indigenous biodiversity and ensure that there is no net loss of Indigenous biodiversity at the date of commencement being August 2023. Regardless of previous decisions made by councillors, and I'm referring to the Planning and Environment Committee meeting of June 2022, referred to in my submission, where there was a vote which removed SNAs from private property. The NPSIB directive is very clear that where there is significant Indigenous vegetation, it is protected and maintained, and its significance can only be changed by qualified ecologists. The NPSIB is also very clear that the assessment of SNAs are to be made without regard to property boundaries. I believe there are means by which the objective of the NPSIB can be achieved whilst providing for the economic well-being of people and communities now and into the future. For example, it is possible for some landowners to offset or compensate within their own property to achieve no net loss of Indigenous biodiversity. In some circumstances, individual landowners could work with council to offset areas of Indigenous vegetation removed from their property and compensate for that loss onto council controlled land. Individual landowners who have Indigenous vegetation present could offset with willing neighbours who don't currently have Indigenous vegetation. The methods by which no net loss of Indigenous biodiversity is achieved within Wellington, whilst providing for the social, economic and cultural well-being of people and communities, requires a much more detailed investigation and discussion than what has currently occurred. But in the interim, the precautionary approach when considering adverse effects on Indigenous biodiversity must be adopted. Commissioners, I ask you to not accept the Section 42A recommendations with regard to not showing significant Indigenous vegetation on private properties in the district plan, and ask you to recommend to councillors to show SNAs on private property in the operative district plan. I also ask you to adopt my recommendations to the policies and rules stated in my submission to achieve no net loss of Indigenous biodiversity when making your recommendations to councillors. With regard to the trimming, pruning or removal of Indigenous vegetation, including areas outside of SNAs, I'm particularly concerned with Council's recommendations via the Section 42A report to permit removal of Indigenous vegetation via Rule Eco R4.1b and R4.2c of between 100 to 3,000 square metres in some areas. It is a highly permissive rule not requiring any offset or compensation and is inconsistent with the objective of the NPSIB. These specific rules need to be removed to ensure that the removal of Indigenous vegetation outside of SNAs better aligns to the NPS, to the objective of the NPS through the use of Eco R4.3 and my recommended changes to Eco P8.2 in my submission. I note that new infrastructure within a significant natural area under Rule Infrastructure Eco R43 has been recommended in the Section 42A report to be a discretionary activity. New infrastructure is likely to involve removal of significant Indigenous vegetation if in a significant natural area, but the standard INF Eco S19 seems to only apply to existing infrastructure, not new. Based on my experiences with council since 1998 in the area that I live, I have concerns that there is a risk of inconsistency between what that discretion will permit and the objective of the NPSIB. Therefore, I ask that the discretionary activity status for INF Eco R43 be changed to restricted discretionary or controlled to minimise the risk of inconsistency with the NPSIB. I've also recommended that subdivision P16 be replaced with the words from Eco P5.1 to P5.6 to ensure consistency with the NPSIB when sub P17 is applied. In closing, I believe it'll be embarrassing and potentially economically damaging to New Zealand if the territorial authority of the capital city and the seat of government was to implement policies and rules that are in contradiction to the government's directive under NPSIB. We're making recommendations to councillors. I ask you to adopt 2 principles to help guide you, being no net loss of Indigenous biodiversity and significant Indigenous vegetation is protected. Thank you.
Thank you. Something that's puzzling me that you referred to verbally, Mr. Doherty, and it's in your written statement, that asking for the status of the rule status for infrastructure be shifted from discretionary to restricted discretionary is reducing
Is it?
reducing the number of
That's
the,
not what I mean.
the
Sorry.
nature of
Thank you.
considerations.
Yes.
Like it's more enabling, not less.
No, that's not what. Thank you for pointing that. The nuances of the definitions sometimes escape.
Okay. So I was a bit puzzled and thinking that didn't seem to be the
No.
message I was getting from you.
From the tone of the submission, yes. Thank you.
And in relation to, talked about your statement, natural justice, like it's pretty clear you understand what's happened and what the nature of the process. The issue that we're grappling with is how many other landowners understood it, because the headline message was council directs urban SNOs be removed, and those who were concerned about urban SNOs basically relaxed. I think that's the concern that Mr. McCutcheon's put to us. Do you think that that's unfounded, that everybody understood that it was still fair game in this process?
Fair game.
That they might come back in?
I think the comms around that decision to remove them was that there were words around until the NPSIB was to be, I guess, notified. So I don't consider it.
So basically well, like from your perspective, the communications was, well, it would all depend on what happened, what the NPSIB did when it finally arrived.
When it finally arrived, yes.
My understanding, the area you gave us a photo of, I have a black and white copy, but that's all right. I know where it is.
Yeah.
That's the Kilmarston land, isn't it?
Parts of it are named 16 Patna and 76 Silverstream, as well as some other areas that are in the area that I live.
When Kilmarston appeared at a previous hearing, they told us they had a certificate of compliance that allowed them to clear bush. So the implication is that irrespective of what we did in this hearing, they would still have that right. Are you aware of that?
I know of the certificate. I'm not sure of the grounds it was written, whether it was based on the resource consent that was granted previously, which had lapsed, or whether it was the fact that I wasn't sure of the rules at the time as to how much could be cleared. But I do know of that certificate.
And you've said in paragraph 21 of your statement, policy 7 allows no discretion beyond avoiding or managing adverse effects. The question for you is, like, I don't know if you heard the discussion that I had with the planner who appeared for Horokiwi Quarries, but managing, like, a policy of managing and effects allows a huge range of responses. Like, yes, you're right, it doesn't allow discretion beyond managing, but the discretion it allows is huge.
I personally think that the words managing need to be taken into the context of the objective, which is no net loss of Indigenous biodiversity and significant. So you manage to achieve that. And it is, I guess, date notified, August 2023. To me, it's sort of references an inventory date. This is the date. And at this point, there's to be no further net loss.
And that then raises the question that I was also discussing with the planner, Ms. Whitney, that how do you move from sort of an overall no net loss? Well, the NBSIB is across the country. Mr. McCutcheon's recommending across the that be translated to across the city, but how do you go from across the city to each individual property? So, for instance, if someone has a garden with a row of native shrubs, or low level, well, they've planted a few trees that are still sort of a metre high. At what point
do you ask for an intervention?
At what point do you have is there good grounds for a management intervention? Because that's, as opposed to somebody who has an entire hillside of pristine native bush, that what's the cutoff?
Well, it's incredibly difficult, but the mechanism is a large communication project with the ratepayers of Wellington, so that they understand that if they want to take some Indigenous vegetation off, then, in theory, they should provide an offset to that. I think my submission, I struck out just 1 or 2 rules, which actually still permits the trimming and pruning of existing. So I still feel that on your individual property, that you can still do that without needing to have a resource consent or something like that. If you just read through the way I've structured that rule R4, you still can do existing activities. I believe you can. It's just when you start to get into larger areas of clearance that it would trigger. But just talking to your point, across New Zealand, there are some activities of the policy that haven't been enacted yet. So it's almost like at a local level that, New Zealand buys carbon credits and things like that. So you have effectively talk to your territorial authority neighbours and work out potentially a scheme by which if your overall net biodiversity is being reduced, that you can maybe purchase between those local authorities. I note that that was deferred in the Section 42A report, that policy. So I guess it comes back to what I said, is it's really in the infancy of this discussion of how to achieve all this.
And the other curveball that we have to negotiate is the direct, at least in the urban area, is the directives of the National Policy Statement for Urban Development, which directs that in the medium density residential, at least 50% of the site be able to be developed to 11 stories, the 3x3 rule, three townhouses, and then in the further down the hill from you, in the valley that the Johnsonville line goes through, it's high density residential with even more directed development, so that there appears to be a conflict between protecting Indigenous biodiversity and the urban development imperative. So do you have a view on that?
But I think it's more of a tension, but I don't know much about the urban development policy. I understand, but I think it's understanding the population growth that you're projecting for the 30 years or whatever. I mean, I haven't done the calculation, but if I just took the view that every single property in Wellington added one more dwelling, and each dwelling was 2.4 people, I think it would meet the requirements of the population growth. So, you know, we can't change the urban development policy statement, but the mechanism, you know, to manage that population growth doesn't necessarily mean that each property owner, you know, has to have the ability to put 3 properties on it or more in case of the higher density. It goes hand in hand with the discussion around the Indigenous biodiversity. It just needs a lot more detail. I mean, overall, the city wants to achieve something, and you know, I know it draws down into individuals, and you're trying to make policies and rules. But yeah, sometimes it needs to pull out again and have a look at it as whether these policies and rules are actually doing what you want.
Okay. Commissioner Dace, do you have any questions for Mr. Doherty?
No, I don't, but hello, Mr. Doherty. It's been a while.
It's been a while. It's good to see you again.
Mr. Murray?
Kia ora, Mr. Doherty. I don't have any further questions for you either, but just wanted to acknowledge your submission and the very clear and well articulated way in which you have set your issues out for us, which will make our deliberations, I'm sure, so much easier. Thank you.
Good luck.
Thank you, Mr. Burke.
Nothing for me, thank you, but thank you for your evidence.
Well-
Oh, your statement.
Well, thank you very much, Mr. Doherty. And we'll roll on. Is it looking over your shoulder, Mr. Edmonds?
Thank you.
But we were going to hear from you after morning tea, but since you're early and we've made up some time, we won't take up any more of your time than we need to. And I'd like you to speak. I should tell you that on Tuesday afternoon, we went on a little tiki tour, and among other things, we parked up on the Riggy, probably in breach of the council's parking rules, and strolled down to figure out where we thought you were, and had a look from the street. So we observed very steep cable car.
Yes, that's the one.
So we've got a sense of the area you're talking about to that extent, from walking down the road and looking at it from the other side of the road.
Good.
But beyond that, we have your written statement. Is there anything you want to highlight in it
Well, I'd just like to go through it. It'd probably only take about 10 minutes just to.
Yeah, well, we have the time, so take us through it.
So, good morning. David Edmonds is my name, as you know, and there are a couple of issues I'd like to raise with the panel. So the first one's about vegetation clearance rules and as they apply to vacant residential lots. And if you've read the submission, you'll know that there's a vacant lot there, which I'm a little concerned about. Bit of background. I've had my name on the title of three sections there, three contiguous residential lots since 1977, so quite some time. In the recent past, the boundary between two of those lots was adjusted. The purpose of that adjustment was that so that a house could be built on the vacant lot, number 6 Terawhiti, as a permitted activity. And just to clarify that, that's within the permitted activity building envelope. It was made wider to accommodate a house so that it could fit in there and not reach the building envelope. That lot's got an area of about 730 square metres and is entirely covered in native bush, as you will have seen, except for a pathway, a gravel path leading through it. And it was interesting to compare it in the 1920s when this photo was taken to what you see now. In the 1920s, it was just regenerating bush. Now it appears to be quite mature bush. So in the draft district plan, the three lots that I'm referring to were covered by an SNA overlay, and I didn't oppose the SNA overlay on two of those sections because they'd already been cleared and developed back in the 1900s for a house and a garden. But I made a submission on the draft plan seeking removal of about 60% of the undeveloped 6 Terawhiti lot from the SNA overlay so that a house suited to the shape and topography of the lot could be built as a permitted activity. And in the picture on the second page there, you can see 6 Terawhiti, which is an unusual shape section for reasons I've described, and the orange area and the house footprint is the bit I was trying to get removed from the SNA for the purposes of building a house. But in the event, the proposed district plan removes the residential zoned land from the SNA overlay, but the Council Officer's Section 42A report recommends general restriction on vegetation clearance so that in a residential zone, a restricted discretionary activity consent would be required to build a house on that vacant section. And as we know, that consent may not be granted or it may come with conditions. The recommended vegetation rule is being put forward as for clearances of more than 100 square metres, which is insufficient to build even a small house. And it's come about, as I understand it, from the submissions by others who want some sort of citywide restriction on indigenous vegetation clearance. Forest and Bird put in 200 square metre limit, for example. But even if the recommended clearance was increased to 200 square metres, while you could put a modest house on that footprint, or footprint of a house on that area, you may need additional clearances for pathways or for fire protection zones or safety concerns around the house. And yeah, so I do understand the tension which was discussed earlier between building houses close to the city and retaining existing indigenous vegetation. But in my further submission on the plan, I raised concerns about the introduction of a general vegetation clearance rule proposed by others, as I consider, I'll change that, fervently believe putting a residential building on a residentially zoned lot should be a permitted activity. So the introduction of any vegetation clearance rules in the district plan would have a disproportionate impact upon vacant lots, for the simple reason that if the lot has already been developed, clearance will have already taken place. And the impact upon an undeveloped or vacant lot, well, it would depend on the vegetation that was there. In some cases, it may have no impact whatsoever. But in the case of Terawhiti or any other bush-covered vacant lot, of necessity, clearance would need to be made to put a house on it. And that clearance would almost certainly be in excess of any clearance rule that comes about. So I guess what I'm wanting to convey is that if any vegetation clearance rules find their way into the district plan, the impact upon vacant lots, the stress on vacant lots, residential lots, needs to be understood. And the first preference would be to exempt all vacant residential lots from any clearance rules that appear in the district plan. And I suspect there are not all that many vacant bush-covered sections in Wellington, bush-covered residential lots in Wellington. So the impact for the city overall is probably not all that great. As an alternate to that, I would like Terawhiti to be exempt from any indigenous vegetation rules. And from the diagram seen earlier, if a house were to be built on that section, about 40% of the section would still remain likely to remain bush covered, and probably, well, you would not have seen in detail, but there are many mature trees on that section outside the area where a house could be built, some 10, 12 meters tall. Hino seem to be the predominant species, but there are very well mahoe, lancewood, karaka, tarata, etc. Lots of different plants, and which I've tried to look after over the years. So that's the first issue I wanted to raise with the panel. And the second one is the road reserve that remains in front of 6 and 8 Terawhiti and 2 and 4 Governor Road, which you'll have seen on your tiki tour. The integrity of that SNA overlay, which is really just a thin strip of road reserve, is called into question because it covers lots of things which wouldn't come under the description of a natural vegetation. There's a couple of garages, a cable car landing, as you saw, pathways, even part of the public footpath appears to be covered by the SNA. And I pointed that out in my submission on the proposed plan, but the section 42A report recommends that that submission be rejected as the site was assessed by Wildlands through a desktop assessment as containing an SNA. I take comfort that on page 69 of that same report, it's noted that now is the best time to ascertain if there are errors in identification, so the corrections can be made, before the panel makes recommendations in respect of SNA extents. So I'll put a few photos at the back end of my submission to support my contention that an error has been made in identification and this thin strip of road reserve should be removed from any SNA. On the next page, you can see the thin strip in front of those 4 sections, and the last page shows what you saw when you wandered down the road, street view. And working from top to bottom, there's a area in front of a neighbouring property there, which is predominantly Tradscandia and Watsonia. There's a lupin tree, which Kiraroo seem to like, broom, and even some blackberry, which I don't think is in the category of significant natural area. Cable car landing, a garage, And then there's a little bit of bush, which you may have noted is they've got a line of agapanthus, which is on the footpath edge. And then further down, another garage, driveway to a neighbouring property, and a small area of green, which again is just wandery stuff on the ground, plus one nio tree. So you take a satellite view of the area, you might think it's covered in native bush because of overhang. You take a street view and clearly it's not. That's the basis of my submission. Thank
It's
you.
all very clear. Mr. Dash, any questions?
No, that's very clear. Thank you. And I think it sort of exemplifies some of the issues that we're facing in terms of urban areas and Indigenous biodiversity in urban areas. So thank you very much for that.
Commissioner Pomare, any questions?
Okay, well, it's good. I look forward to seeing the SNA removed,
Well,
amongst other things. Okay, thanks very much.
before you go, I think that there's one follow-up question that I need to ask Mr. McCutcheon, so just be aware of
Yes.
it. If you just pause for a moment. I think Mr. Edmonds' question is a subset of a larger issue that Ms. Whitney's was raising, which is if there is a general out of SNA rules, should the exceptions that would apply to SNAs also apply to the outside SNA rule? Because there's an exception in the SNAs for a vacant lot.
Oh, okay, I was not aware of that.
So that's something for Mr. McCutcheon to ponder and advise us on in reply.
Just in summary, because I'm not familiar with it, can you just explain to me what that what applies to a vacant lot within an SNA?
There is a rule that says that it's not, well, there is a direction that says that rather than all effects being avoided, you move to the effects management hierarchy, which is allowing for some effects and offsetting.
Oh, yeah.
That
So
kind of,
you grow some bush somewhere else to
yes, that's right.
make up for the removal. I
And it
I
will,
don't have a vacant section somewhere else to grow any bush. If I could convince others to do so.
indeed. But thank you very much, Mr. Edmonds.
Actually, this is a complete aside and unrelated to this. I was helping a friend who's involved in pest trapping on Mount Victoria recently. And in addition to the pest trapping, he's also clearing broom and other exotics and planting native bush. And I've been doing this with him for 18 months, 2 years or so. And it's amazing how quickly one can get the native plants established.
Well, I think that the ecological evidence we said was that like the natives will outperform the weeds over time.
Oh, yes, I think that's the case. It's come about because there was an area close to the road which the council, I think, had removed the pine trees and macrocarpa. And as a result, weeds, sort of exotics have sort of started to grow. But if you can clear those out and put natives within their midst, they seem to thrive. And yeah, some are looking pretty good, actually. Okay.
Thank you.
Thanks for your
But
time.
many thanks for your time. So we will adjourn now. We'll restart when Ms. Cadenhead arrives for Tyers Stream Group, but not before 5 to 11. We resume the hearing, Ms. Cadenhead. Welcome again.
Thank you. If you've read what I sent through a couple of days ago, then I won't bother going through it, just make a few points, so.
Yes, we have read it, but if you could want to highlight anything that you of particular interest before we ask you some questions, that'd be good.
Basically, you are obliged to protect by at this point in time, obviously, things might change. How it's done and what it's called are up to some debate. Engineers or land with plants on absolutely protect the hydrology of the stream. What has been crashed because of infill housing and many hard surfaces being added in the catchment. So the hydrology has already been thrashed. And so we've got a lot of significance to mine, which is kind of good. Sorry, at the moment, there are quite a few native fish species in the stream, including tuna, long and short-finned eels, and quite a few other species. SNAs have a part to play because they retain vegetation. They also improve the carrying capacity of the reserve, but the key thing we're concerned about is the more vegetation that we can keep in the catchment, especially on the edges of the reserve. And I did send a small PowerPoint, which you've got the pictures, basically showing the that it's very steep. That's why I put the contours in, showing the catchment and where it goes, and showing the purple was the proposed SNAs and the ones on residential property that are proposed to be removed. It's not a big area, but it is important because it's at the top of the steep bit. And also, if you notice the sort of orange bit going up, it's protecting more of that stream edge. So basically, we want some sort of protection around the reserve to protect their hydrology. And I think unless there's something else, you can ask me some questions.
Thank you. The bottom of the first page of your statement, you're talking about good incentives can aid the process.
I think that it was appalling that the council didn't have some incentives built in before they even suggested SNAs to people. Like, I think decent rates relief. It's absolutely essential. If you are taking away people's rights to some extent. Personally, it's probably unaffordable. I would put 100% rates relief on the land with the SNA, so not your house and the rest of your property, assuming you obey the rules. But if that's not feasible, then even 10%, it shows that there's a community benefit here. To say you'll give them some weed control advice is a bit pathetic. So yeah, decent incentives. Like in Nelson, if you've got a heritage listed property and you want to do something that the heritage listing triggers a resource consent, that is free. If it's, you want to change your bathroom or something, obviously, or some other thing that triggers a resource consent, it isn't free. But if it's a heritage thing, there's no cost. And one, it means people do it. They don't just try and sneak it. But secondly, it's showing the public benefit of your building. And I think you could do that with SNAs. If the SNA is triggering the resource consent, it should be free. That's not a huge cost either to council usually. Yeah, I also wondered about, it's not on here, but I also wondered about, there's a voluntary you know, if your property has been suggested has the quality of an SNA, then if you know, maybe you could choose to have it listed. Like not everybody was opposed. And a lot of the land around the Tyers stream, reserve and catchment, basically it's very steep. It's pretty friable, rotten rock. And probably the reason it's still got vegetation is because it's so steep and so difficult to maneuver. And a lot of it's landlocked, so there's no vehicle access or easy way to get it. I think there'll be people that would be absolutely keen to have it listed if they got 10% rates relief. Actually, one point which is not listed, I'll also make briefly is in terms of infrastructure and SNAs, we basically agreed with what had been written. But it's not necessarily what they're doing, and we would love the wastewater pipe through Tyers Stream Reserve to be maintained a bit better. It's not so much what they're doing as how they're doing it. We had 2 lots of mending recently. One, they did brilliantly. It was a very difficult job. A slip had taken out a section of the wastewater pipe. It was very, very steep. They put a track in without hardly touching a tree. They mended it, well, they said they were sitting on the edge of a cliff extremely quickly and well, and they did no damage. Another little job they did, which was simpler, there was a tree, quite a big tree, growing on top of the wastewater line, and they cut it down, which was sensible, but they left it in the stream corridor, and that was starting to cause real problems. So the Tyers Stream group, we cut it up and dragged it out of the, so that was really, you know, they had to cut the tree down. That wasn't the issue, but what they then did with it was an issue. So it's thinking ahead and thinking, you know, how are we going to do this? Like if they have to put a track in to mend the wastewater pipe, they need to backhaul, not just push all the stuff into the stream or place the material, you know, things like that. So it's not necessarily what, because yes, they have to mend it. It's the care that's taken. But generally they are good.
Okay. Commissioner Burge, did you have any questions, Ms. Cadenhead?
I don't have any questions, actually. That's quite clear. And I guess your focus is on the Tyers streams. So I'm looking at my screen of your submission. So your focus is on the orange, you know, areas that have been removed over the residential sites, but you've commented generally too about how
the same thing applies to the whole city.
Yeah.
But the submission is from the Tyers Stream group, so
Yes.
we try to focus on just the things that impact this Tyers Stream. But the same thing applies to the whole city.
Yeah. So through this process, you're probably aware that there's been, well, the SNA over those residential sites has been removed. But there's been a proposal to have a vegetation clearance rule over areas outside SNAs.
It's quite big though.
Sorry, what do you mean?
I think didn't it say that you could clear up to, I haven't kept up with it all. I thought it was up to 3,000 square meters or something.
In the rural area, but for residential, it was 100 square meters proposed at the moment.
Like if that was in the wrong place, then that's significant. Like if you did that right beside the stream, then that is significant. Depending on how you did it, if you cleared the stream, let's say 3 meters from the edge of the stream in a big strip, then that could be significant. Partly because of the topography, you'd end up with a ton of sediment in until something else came back, or.
Do you, we had a previous submitter before you came in, and he has a residential lot that is covered in bush that's not developed yet, and he wants to be able to develop it, but he would.
But the rules did allow, if you didn't have a house on your residential lot, they allowed for a house. The original rules, the rules when we put the original submission in, did allow for if you didn't already have a house on the block, because it's residential, so it should be a house, then it allowed for that.
Yeah.
And I don't see a problem if it's done carefully, because otherwise you've got, like, if that piece of land has got very high biodiversity, then maybe the council should be buying it. If it's in the more moderate biodiversity or, lower, then you can put a house in if you're careful. If you bulldoze a huge amount to put in roads and a big building platform, then maybe not so much. But if you're using piles and being careful, then I think that's reasonable. But that was the original rules.
Yeah. Thank you. That's all I had.
Thank you. I think I've had the benefit of your group coming on a couple of times for the hearings I've been involved in, and it is very clear your position. So thank you for that.
Yes, it should be. I think we've been 4 times, maybe.
Yes.
Actually 5, I think. The way it's cut up, like, it was a short overall submission, but yeah, the way it was chopped. Yeah.
Murray, did you have any questions?
Oh, actually, I did think your recommendations to the council on the last block were good. I was pretty pleased.
Well, thank you very much for coming along. No questions for you, but you make a good point about the incentives, and we understand that will be addressed in the plan change process. Yeah.
Very much.
Thank you.
Okay. It is morning. Welcome. Over to you.
Michael, shall I start?
Yep. Mr. Watson, we've seen before. Recognised across crowded room, Mr. Siegel. So, Mr. Grace. And
Good morning. My name is Michael Grace. I'm a director and shareholder of Terawhiti Farming Company Limited, Te Camera Station Limited, and Te Marama Limited. All 3 properties are collectively known and farmed as Terawhiti Station. The station is the largest holding in Wellington and comprises approximately 4,800 hectares. I'm here today speaking on behalf of my family's significant interest in this policy. Our main points of the submission are: number 1, infringement on private property rights. At the core of the issue is the infringement on private property rights. The designation of SNAs on private land involves identifying areas of significant Indigenous vegetation or habitats of Indigenous fauna, and imposing restrictions on how these areas can be used. For us as landowners, this means that significant portions of the land could be subject to controls that limit development, farming practices, and even access. The unilateral imposition of SNAs without the owner's consent or adequate compensation is an unjust encroachment on the foundational principle of private property rights. Number 2, unfair land use restrictions. The restrictions imposed by SNAs are often broad and can severely limit the economic potential of the land. For a property like Terawhiti Station, which has a long and proud agricultural history, these restrictions can be particularly damaging. SNAs directly limit land use productivity, while at the same time Wellington City Council's rate demands only increases. This is unjust. Number 3, encouragement of voluntary conservation. Fear of stricter regulations discourages landowners from voluntarily engaging with and enhancing ecological value, both flora and fauna. Terawhiti Station was the foundational property from which the Capital Kiwi program was able to flourish. We are voluntarily and actively engaging in activities that enhance Wellington's environment. However, the risk of SNAs and other potential restrictions being forced onto the station directly risks these conservation efforts. Why would we enter into any more initiatives if they may trigger SNA designations and further restrictions? Why would we? No one can say that we oppose conservation. We are not opposed to conservation. We're opposed to council imposing restrictive SNA overlays. It's not councils imposing this legislation, you might say, which brings me to my next point. Number 4, legislative changes. The recent introduction of the Resource Management Amendment Bill by the government has further highlighted the challenges associated with SNAs on private property. This bill, which suspends the mandatory identification and regulation of SNAs, underscores the growing recognition of the unfair burden these designations place on landowners. By shifting towards a more flexible and voluntary approach to environmental protection, the government acknowledges that the previous SNA framework was too rigid and did not adequately consider the rights and interests of property owners. This legislative change is significant for currently identified SNAs, as it allows for the possibility of re-evaluating or even removing SNA designations that were imposed without proper consultation or consideration of the economic impacts on landowners. For Terawhiti Station, this shift represents a crucial step towards restoring the balance between environmental stewardship and property rights. It also serves as a clear indication that this government is willing to listen to the concerns of landowners and adjust its policies accordingly. Wellington City Council should do the same. Number 5, hypocrisy in Wellington City Council's SNA approach. Wellington City Council's decision to apply SNAs exclusively to rural properties while avoiding the imposition of urban properties with significant Indigenous biodiversity highlights a glaring inconsistency in its approach to environmental protection, and quite frankly, its credibility. The Council's decision appears to be driven more by political and social consideration, i.e. let's avoid the greater urban backlash and just go after the easy option, a smaller number of rural landowners. Number 6, in conclusion, Terawhiti Station vehemently opposes the imposition of SNAs on private properties without landowner consent. The designation of SNAs infringes on our property rights, imposes unfair restrictions on land use, and discourages the very conservation efforts we are voluntarily engaged with. If I haven't been clear enough thus far, we are asking the panel to remove all SNAs from Terawhiti Station. Thank you.
I think we got that message. Mr. Grace, the first thing you could do for me is if you could describe the boundaries of the station, because I have a very general idea of basically thinking.
Sure.
Sort of, it's more go that way.
Yeah, right.
And eventually you'll get to Terawhiti.
Well, so look where we are.
Yes.
That way, yeah. If you're at Macra Beach, Meridian's Macra Farm is just to the south of Macra Beach. Our northern boundary is to the south of that, and that's Te Camera Station. That is at the northeast end of Te Ika Amaru Bay. Runs roughly southeast to South Macra Road. Runs down to the south coast, Quarries Stream mouth, around properties on that South Macra Road, though, including the golf course. Te Marama is actually on the eastern side of South Macra Road, and that runs up to the back of just below Makata Peak. And then the western boundaries are Cook Strait and Otaronga Bay southwest. Southeast boundary is there basically Quarries Stream mouth.
Yes, I get you.
Sorry, I didn't provide a map, but
No, I can visualize it. I played a lot of golf at Quarries.
Oh yeah, right. Well, so all the hills behind you are basically on the Te Camera Station. Yeah.
And so that you own the land underlying the west wind turbines.
Correct, on the southern end, yes.
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 Gotcha. And I think understand the point of principle. One of the issues we have in talking about legislative change is, of course, government talks a lot about change, but nothing's happened yet.
Sure.
And we're in the process of, we're assembling, getting commentary on basis of the law as it currently exists.
Sure.
And when it changes, we'll seek further commentary on, well, what are the implications of the change? Now, at the moment, what's in the bill at the moment wouldn't actually assist you a whole lot.
It's more winds of change, I suppose, what
Yes.
what the point is. But obviously the panel is also has the ability to remove
Yeah.
at the moment under current legislation. So there's, I guess it's a two-part
Yeah.
process there. In our view is removal from the property. As I say in the presentation, it doesn't mean that we are anti-conservation. In fact, we're doing quite a lot in that space, but the imposition on the land without the consent is our concern.
And you said that you're 4,800 hectares. What proportion of the property would be in SNA?
SNA low. Unfortunately, I missed the outstanding, the ONA presentation. So I don't know what the percentage is. It's low on a percentage basis.
What's that, sorry?
It's low on a percentage basis. On a percentage basis, I wouldn't know. Sorry, on the
but,
SNA percentage.
Because the so obviously it's a point of principle. The part of the council's analysis of rural land is that particularly the larger properties like yours, well, it's only in bush because effectively it was probably unusable productively. And to what extent, like we heard yesterday from a couple of people, including Mr. Segal, who's just ducked out. Oh no, yeah, happy smiling face over your back shoulder. That and that's not true of the smaller properties, but is it true of yours? That
I don't think it's a hard and fast rule. I mean, we went through serious economic deprivation for a while in particularly the 80s and 90s, taking off the subsidies, etc. So it was less around the value of the land being farmed. It was more around the fact that farming was in a very tough state, and the areas that are now have regenerated, were harder areas to potentially fence. And therefore we weren't necessarily using them as intensively. So it was a cost rather than quality of the land under regeneration. So we've been more selective with the areas that we were using.
Mr. Dace, do you have any questions, Mr. Grace?
Yeah, only one. As the chair said, I think your point of principle is well understood. You mentioned that you know you're a supporter in terms of conservation efforts yourself on the property. Can you just outline what you're doing? Is potentially doing additional fencing or predator control, or what sort of things are you doing in terms of management and support of Indigenous biodiversity generally?
Yeah, that's a great question. Well, it's not just us, because there's a number of people and entities involved. We're obviously working very closely with the regional council on pest control, particularly possum control. We are retiring areas. Certainly there's significant areas that we've retired from farming and which are regenerating voluntarily. We haven't put those areas necessarily into QE2 covenants, which we could do, and we could receive funding for fencing, etc. But we, as a family, have decided we don't want to impose long-term potential restrictions on a property for future generations without their say. That's our view. So we are doing those things voluntarily, but not necessarily through frameworks like Kiwi2. We obviously have the Capital Kiwi program in the 4 at the moment, and I'm a trustee for the Capital Kiwi Trust Board. We're doing a lot of planting, a lot of native replanting. So yes, we are doing what we can within budgets available and time, because these things are a slow process. But we are certainly trying to leave the environment in a better state than it once was. But there are limits to that. We still need to pay rates and we still need to pay bills. So while the percentage, Commissioner Robinson, isn't necessarily significant, it is the act of the overlays and imposition of SNAs on the land that is our issue.
And in terms of farming activity, it's sheep and beef grazing. Is there any other sort of agricultural money making things actually happening on the station itself, and particularly in the the primary production space anyway?
Primary production, goats. So
Farming goats.
Yeah, well, as I say, we were in dire economic straits, 80s and 90s, and goats are a low input farming outcome really. So you don't need to shear goats, you don't need to drench goats. So we introduced goats as another potential income stream at the time, because obviously cost inputs were no good if you're making money out of wool or sheep. So yes, goats are also the only thing that will eat the proliferation of Darwin's barberry and gorse that are across the landscape. So they were originally introduced as an economic tool for the farm, but they also are, I guess, an ecological tool for us in terms of trying to hold back things like gorse.
I'd understood that in a lot of rural areas that is active, they're treated more like a pest species, if you like, because they're fairly indiscriminate about what they do eat.
Yes, yeah, that's why we've at least the fencing on the property is much better than it used to be. We've got money to fence now, and previously that was indiscriminate. We are absolutely trying to reduce the numbers. There's no doubt about that. The problem is, there's issues, but we are trying to reduce the numbers. But they do have a part to play in a smaller amount than they currently are, for sure.
Okay, thank you.
Seen a lot of them on Quarry Golf Club.
Yeah. Yeah, well, our lovely neighbours at Quarries, we were working with them on the fencing boundary at the moment. So,
yeah,
neighbourly issues. It's all good. So apologies if they've got onto the green.
Well, I don't
You can blame your results on the greens.
No, it's more that you've acquired a lot of my golf balls.
No doubt.
Commissioner Birch, do you have any questions of Mr. Grace?
I don't have any questions, thank you, but I certainly understand that the problem is, as I understand it, it's the combination of ONFL, SNAs, ridgelines, hilltops, and special amenity. I've got in front of me, so I can see that you've got a proliferation of overlays. The SNA area, as you say, appears very small. I'm assuming I'm looking at the right property.
Yes, yeah, it is on a percentage basis, absolutely.
Yeah, it's the combination of the whole lot rather than the parts. Yeah.
Correct.
Yeah.
Yeah.
Correct.
As I say, I missed the ONA session, unfortunately, because that's probably the bigger issue for us as well. So it's all of those overlays that combined to make things very difficult.
The restrictions that it places. Yeah, I completely understand your issue. Thank you.
Amari, any questions?
Kia ora. Thanks very much for coming along this morning for your submission. It does exemplify a lot of the issues that have been raised by other submitters. If there were appropriate incentives provided and the opportunity to work in partnership with the council,
sure,
to develop appropriate ways of providing for SNAs, for want of better term, while also enabling the sorts of activities that you're required and need to be able to undertake in order to preserve the rural productivity of your property. Would that help to mitigate the concerns that you've raised, or is it more a matter of principle?
No, I think that would, if that was a conversation at the start in 2020, I think that would have been better received, should I say? Yes.
Yes.
Yep, absolutely.
Okay, thank you.
I think that's all we have for Mr. Grace, but Mr. Watson, did I detect that you're going to speak in support of Mr. Grace's submission? Or Mrs.
Thank you for your
Watson?
time.
Thank you very much.
Permission to speak today?
Yeah.
So let's just be clear. There are some legal rules, but so long as you're speaking to Mr. Grace's submission, but given the ambit of Mr. Grace's submission, that leaves you a lot of leeway. Since he's starting with no SNAs in rural areas.
Thanks for giving us.
Thank you. Well, why don't you take us through your presentation?
Well, we'll make a start. We are Stephen and Christine Watson, trustees of Long Gully Station Trust, and we purchased the 830 hectare farm station for our family back in 1993. Long Gully is still managed as 11 parcels of land within the one farm station, and I've got the addresses there that you can look up later. And if you turn to the back page, I've included a map of the boundaries of Long Gully Station, so you can see that in relation to the city. Terawhiti is to the west of us, and just continuing here, Long Gully Station, Canal Station and Terawhiti Station, whose original SNA submission we support today, make up the entire southwestern coastal peninsula of Wellington, all privately owned rural properties. All oppose mandatory SNAs without landowner agreement. We are here today to support Terawhiti Station's original submission opposing SNA on private rural properties. We vehemently oppose SNAs being imposed on private rural land.
Okay, I'll carry on. We as landowners were not properly consulted, if at all, in the drafting and the implications of both SNAs and PDP. Any questions we did ask were ignored. The PDP was written over COVID lockdowns without any requested and, might we add, promised consultation. This council is intentionally destroying the social fabric of our rural community with both PDP and SNA planning overreach and must be stopped. The Purple Haze SNA overlay is a blanket subjective, unscientific, unsubstantiated desktop exercise that in the very least should require substantive expert evidence given the gravity of its effects on the rural community. As case in point evidence, the SNA overlay WC144 includes almost all of our property at 692 Southern Thread Road in Brooklyn, resulting in 94% of that 49 hectare property being confiscated. Lazy mapping hasn't even removed the physical Southern Thread Road that runs through the property. There's no way this road could ever be described as significantly natural, and SNA will make the ongoing maintenance of this road impossible without first obtaining resource consents. This new SNA grab of almost our total land parcel is in spite of us voluntarily protecting what was then identified as being truly significant within a QE2 land covenant. We're the ones who have chosen to allow the regeneration and restoration for 30 years in some cases to take place by removing stock and culling goats, not clearing regeneration when we legally could have done so. This has made the land what it is today, but in all fairness, we must be allowed to adapt and utilise our private rural land in ways that enable us to remain economically viable. We privately manage a combined land parcel larger than the whole Wellington CBD, including Island Bay, but do not have the luxury of rate space funding. In fact, the exact opposite. We pay rates to our wasteful and incompetent council that burdens us with rules that they dare not apply to themselves and continues to spend money on SNAs when our government has suspended requirements for councils to identify them. SNAs on our private rural land are craftily drafted legal documents that are specifically designed to further cripple our rural community by limiting new activities and development that can take place on that land. In their current form, they represent a confiscation of property rights and undermine conservation efforts by the people who care most about the environment, the people who make a living from it. SNA adds further layers of arbitrary, nonsensical rules that blatantly rob property owners of their right to utilise and maintain and enjoy their freehold land. Both the PDP and SNAs are blatant Marxist, communist, private land confiscation tools that are the tip of the iceberg for what is coming, and democracy needs to wake up. In our minds, all the snouts in the trough, including this hearing, are complicit in this land theft if they do not uphold private property rights. Sadly, the Crown's same deceitful intent that stole Indigenous land in 1840 is being repeated in this SNA policy in 24. Council has not learned from our shameful colonial history by its current behaviour in not removing SNAs from private rural land. This mirrors the treaty's failure to protect sacred property rights, resulting in land confiscation. The irony now being that the rural landowner is also required to pay oppressive property rates that are then used to fund this Crown theft. Look at the multi-injustice of this SNA overlay process. Rural landowners were not properly consulted in the drafting of either the PDP nor SNA. The fact that we're even allowed to be present here today and speak at the mercy of the commissioners is an injustice. Shouldn't landowners' voices be sought out throughout the whole process of their land confiscation? The SNA land was confiscated based on a subjective desktop exercise. Rural landowners are the only ones attending this hearing who have anything and everything to lose. We're the only ones whose property rights and freehold land is being stolen by these proposed SNA and PDP rules. Rural landowners are the only ones in this room today not being paid to attend this hearing. Rural landowners are the only ones in this room today who don't have funded legal representation. The removal by SNA of rural landowners' rights to use and enjoy their freehold land is unjust, undemocratic. We believe the only reason SNAs were removed from private urban land was recognition of the massive opposition that would have resulted. We also believe rural landowners are viewed as easy picking. We're fewer in number, too busy trying to survive to be able to successfully oppose this theft. Anyone who is complicit in this SNA land theft is morally bankrupt and at the very least should be ashamed of themselves. Regarding the cost, the proposed SNA cripples our private land options while leaving us to pay the rates. This proposed SNA reduces our multi-million-dollar property to unproductive conservation value. The true cost to the landowner is the difference between the value of 1 hectare offered for sale on the open market without the encumbrance of SNA, as opposed to the same hectare offered with the SNA overlay. Should council be required to pay this compensation for all private rural SNA land, they would undoubtedly re-examine its significance, or perhaps that's their end game, buy our rural land for next to nothing. 30% of our working day as rural landowners are spent in addressing oppressive, unpaid, unproductive WCC compliance that doesn't produce or create anything additional of value. These battles are to simply maintain freehold property rights New Zealanders believe are innate, yet they are being constantly eroded by socialist policy planners. The full financial loss, the detrimental physical, the mental cost to private landowners is at times unbearable. It's certainly not measurable. What are some practical day-to-day implications of SNA and PDP overlay, you might ask? Well, compliance officers now issue non-compliance notices requiring all water tanks, firewood splitting, firewood storage containers, maintenance of farm tracks, access ways, and most importantly, fire breaks to all now require resource consents. The average resource consent costs us $6,000 to $20,000, not the $2,500 non-notified application fee often quoted. This is not financially sustainable for the rural community, certainly not for our family. Interesting, however, when we asked if the recently maintained access ways and fire breaks on council land adjoining our land had first obtained a resource consent. We were told council doesn't need resource consent as it's public land. This is happening right now in our real time, in our time. Over the 30 years we've owned Long Gully Station, these changes have been insidious and creeping, making living in the rural area and maintaining rural land a nightmare. It has been brought about by successive weasel wording changes to permitted activities in the rural area. This latest Wellington PDP has reduced permitted activities in the rural area to nonsensical definitions that are now being applied subjectively by Wellington City compliance officers. The average person might argue this couldn't happen in our sacred democracy, but yes, compliance officers are already enforcing it with abatement notices. There's nothing less than socialist oppression of private landowners. We don't believe this has happened accidentally. It's not conspiracy theory. This is happening in plain sight, aided by an army of complicit socialist planners and compliance enforcement. Clearly, SNA is designed to make private land ownership so hard. Private ownership will be given up. For humanity's sake, we need to stop the socialist engineering of mankind off the land, of which we have no shortage, into lifelong state farm dependency. SNA as a private land confiscation that Klaus Schwab and Marx and Stalin and Mao would applaud. New Zealanders need to wake up. Given SNA is a New Zealand forest and bird driven policy, can the commissioners of this hearing please confirm they have no conflict of interest, being either members or associated to this society in any way? Finally, as commissioners, you'll be aware that in March 2024, Associate Environment Minister Andrew Hogarth made the announcement to suspend the need to comply with the SNA rules. In his press release statement, he said, as it stands, SNA has identified private property limit new activities and development that can take place on that property. In their current form, they represent a confiscation of property rights and undermine conservation efforts by the people who care most about the environment, the people who make a living from it. Given government's policy agrees with us that in their current form on private land, SNAs represent a confiscation of property rights, they must be removed by the recommendation of the commissioners of this hearing or by further appeal to the Environment Court. So in support of Terawhiti Station submission, we therefore ask that the commissioners of this hearing recommend all SNAs be removed from private rural land unless that private landowner consents to its overlay. Thank you. We value this opportunity to answer any questions you may have now.
Not a question, but an observation, Mrs. Watson. One of the problems we have is
I'm
that
just, excuse me for a moment, could you speak up, because I'm not, I'm a little hard of hearing, sorry.
understand. Yes, I have that problem. One of the problems we have is that, yes, you're right, absolutely right, and Mr. Grace has already referred us to the announcements from Minister Hogarth, but announcements from the Beehive don't change the law. The government has to follow through and actually change the law, and when it does, we'll consider what the implications are of the change. So one of the issues, because of precisely when this hearing is occurring, and we've delayed it as long as we can because you can see the goalposts shifting in front of your eyes. This is the last hearing for that reason, but they haven't moved yet. So that's an observation. We've got to apply the law as it currently exists, and when it changes, we'll think about, well, how's it changed and where does that take us? So that's just for your information. Like, I understand completely where you're coming from. You're not the only submitter to have put this position, probably more passionately than some, but we understand the issues. But I'll ask my colleagues if they have any questions. Mr. Dash.
Yeah, thank you for that. I'm just flicking my way through Mr. Brown's email to you, 18th of June, which you put in there. So
Good.
Is this related to your $20,000 worth of consent costs, or because it's talking about these two dwellings which didn't appear consented. There was a firewood business and other non-rural structures and so forth. So I'm just trying to understand the linkage between that and what you were saying before.
Sorry, I don't quite understand the question, but this is a current letter that's being addressed at the moment. Resource consents, and I have another resource consent underway at the moment, which includes the relocation of a dwelling, but also includes water tanks and septic tank.
Yeah, okay, but in your presentation, you mentioned average resource consent costs of $6,000 to $20,000.
Yes.
So that's unrelated to Mr. Brown's email to you as of June.
Yes, it is. That's unrelated. However, I can give you so many more examples of actual costs. That the 2,500, and in fact, I just put another one in yesterday. It's 2,700 now for the application fee. You then have to pay your planner and landscape architect or whoever, whatever experts you need to make that submission, and you easily exceed $6,000. Okay, so as another example, we moved. I noticed you said Mr. Robinson, you said you were involved with the hilltop and ridgeline overlay. That was the very worst policy that was inflicted on us that I should have appealed at the time. I did make a submission, but we didn't appeal it to the Environment Court, and it was another, in my view anyway, it was another lazy overlay that went from the city side that was without dispute in view of the city, and it went over the other side into Long Gully, down on the same contour as the city side, and it can't be viewed from anywhere. And this is how it plays out in real time, just because you don't think that they're significant when you sign them off. How it plays out in real time is we had a house site on our lot 15 that had to be moved, and we tried to move it up into the hilltop and ridge lines, and the cost of doing that cost me $30,000 to move it up into the hilltop and ridge lines. Not only did we have to have landscape and planners, but we had to have an architect design the house, the specific house that was going to go on that site, to be approved to move a house site.
Yeah, okay.
Yeah.
And so how's all that related to
no, before you go on, Lindsay, can I just point out, you haven't lost the chance. The decisions on the ridgeline and hilltop overlay haven't been made yet.
Yeah.
So if you've got a submission, you will have a right of appeal. You just need to watch out for the council's decisions, which will be probably end of next April, March, April. So sorry, just pick that up.
Sorry for my convoluted answer. The question that what I was really trying to say was that cost us over $30,000 just to move a house site.
Understood. Okay. I was just having a read through Mr. Brown's email.
Yeah.
Which sees that you need consent for a whole lot of stuff which is happening there, according to him. Yes. And I wondered whether those costs were what you're in the middle of doing now, or were historical things for other things which might have happened.
I would imagine to address Mr. Brown's concerns here is going to cost us 30 grand.
Okay.
And what I've just highlighted here, we need a resource consent now for a water tank in the rural area. If you rolled that out over New Zealand, there's probably 500,000 rural, and this is, he's expecting rural tank, water tanks to be retrospectively consented, right? So you roll this out over New Zealand, it's absolute compliance overreach, and it needs to stop.
Okay, well that's understood.
Yep.
So how much of your property or your overall conglomeration of titles that you have is covered by the SNA overlay? Approximately percentage wise?
I couldn't say in relation, because this is evidence and it's got to be correct. I'm sorry, I don't know that, but on different titles, it's different amounts. Why I've highlighted this one title is I've said here, because I wanted to be conservative, it's 94. If you actually look at it, it's more like about 98% of that property is SNA.
Okay.
And we've already got a QE2 covenant on it, which in our minds is the correct way I mean, we would much rather have the QE2 having a covenant on it than this with council just using it as a tool to punish us.
All right, thank you.
Thanks very much for your submission. I don't have too many questions for you. The discussion's been very helpful this morning and you've articulated your position very clearly. So I understand where you're coming from. Just in relation to your Appendix A again, the letter from the council officer in relation to the compliance breaches, which are now requiring resource consent. I'm just wondering if you could clarify your understanding anyway of the extent to which the compliance breaches are related to what would be considered to be non-rural activities occurring within the rural zone as opposed to the SNAs.
All I would say about this letter is if you just reference the third line down, he references it just to use as a tool to include. Okay, so he says this property is zoned rural and has SNAs as well. Okay, he didn't put that there. He didn't put that there just for the sake of informing us. Yep. He's just saying it has SNAs as well. Yes. So he intends to use any restrictions that SNA has to further strengthen his position on those activities.
I understand where you're coming from.
Yep.
I was just really wanting to get a steer, but it's perfectly fine if you're not clear yourself on the extent to which these breaches might be due to what are perceived to be non-rural activities occurring within the rural zone, as opposed to any impositions that the SNAs might be creating for you.
Yes. Yeah, so I would agree, I think, with what Commissioner Burge said earlier. It's really this multi-layered level of compliance you have to meet that essentially leaves you with nothing you can do as a permitted activity in the rural area. I mean, in fact, I draw your attention. I mean, you asked one of the submitters yesterday to reread the permitted activities in the rural area. I would encourage all the commissioners to read it because it's a nonsensical statement. I mean, if you click on what a rural activity is, you read what that is. And my reading of it, and you can go away and clarify this, my reading of it is that you can store pony poo, but you can't have a pony. You need a resource consent for a pony. Now, I've asked council to clarify that for me. They haven't come back, but that's how nonsensical the actual rules are that we have to try and live within.
Yes, well, there is a suggestion here in the letter that that there are no rural activities currently.
I'm just going. What planet is this guy living on? No rural activities. You know, I would have thought firewood splitting and storage, drying, is a rural activity. Yes. Any normal, reasonable New Zealander would expect that to be a rural activity.
And so, from your perspective. You're managing and utilising your rural property
as best we can.
Yes, and in a way that would be consistent with what would be normally and reasonably regarded as rural uses.
Yes, we believe so. 100%. And yes, we do value the environment. It is what it is because we've allowed it to be. But interestingly enough, when this SNA was originally proposed, we got a consent to remove native regeneration. So we're sitting on a consent that we can aerially spray it, we can do whatever we like with it. We don't intend to do that. We can still do it, even with this SNA. We've got a consent to do it. But that's not our heart. Our heart, we love the land. And you know, I honestly, I think, you know, what it does, it puts us in a position where we appreciate what Māori lost in 1840. And if anybody's going to confiscate this land, it should be confiscated back to Māori, not to the Wellington City Council.
Tēnā koe.
Yeah.
Thank you very much.
Mr. Birch, any questions?
It's looking at the rural activities definition as we're talking about it.
Yeah, let's talk to it.
And well, you've seen it.
Well, I think no, let's not, because
Yeah.
this isn't the
No,
rural
and
activity
it's-
hearing.
Thanks. So I don't really have any questions as such. I completely understand your submission. I completely understand, you know, your message. As I said before, it's a combination of restrictions over your property that's causing your headache. And you know, the council have heard your submission. You know, they need to, obviously they will look at your submission more closely and the you know, specific issues that you've drawn attention to. Yeah, so we will see what they come back with and look at both sides of the equation. Yeah, but I certainly appreciate your message, loud and clear. Thank you.
Thank you for your time, and to Mr. Grace also. Yeah.
There is a tremendous amount of pressure on the property that we talked about yesterday, because we are the front line
Well,
on that over. And it's been the other overlay that's caused us. a restriction.
yeah, I understand that.
We submitted in regard to the whole district plan, focusing on the SNAs, because that was the sentence that we used. How do we submit a proposal to specify the actual intent? It was in the documentation yesterday. Overlay.
I can't answer that. I suggest you talk to the friend of submitters.
Thank you.
And who will look at your submitter and submission and be able to advise you.
Oh, will do.
So, Mr. Leijer.
Sorry, hello.
Radio. So we're just presenting on the property at 62 Kai Wharewhara Road, which was subject to natural open space zone, and we submitted in hearing 7 to get it rezoned to medium density. Upon reading the section 42A report in relation to the SNA, we found that the submission to remove the SNA from the property wasn't supported. However, we've read the rebuttal evidence, and it appears that if the land is rezoned to residential, that the SNAs will be removed from that part, which is consistent with the plan, which is essentially the outcome that the applicant wants. They don't want an SNA over the residential zoned land if that goes through. A further inspection into the zoning shows that there's a portion of the site that is mixed use zone. In my evidence that I've presented earlier, I noted that the SNA is still over the mixed use zone as well, which as the permitted rules allow residential activity above ground level, it's reasonable that we can potentially make this area of the site sympathetic with the character, amenity and outcomes of a residential zone. So it's kind of hard to differentiate between what makes a residential zone if you're allowed to do residential activities in it. I appreciate this was talked to in the rebuttal evidence as well. One thing I did not submit with the evidence was the fact there was a resource consent applied for the site as well, a 6-lot subdivision, which includes 5 residential lots and the remaining lot with the existing building on site. And this is what the certificate of compliance in relation to the vegetation clearance is for as well. So, which I've got with me today, if required.
So, question for you, Mr. Leijer, can you give us a copy of the certificate of compliance?
Do you want a hard copy or emailed to you later?
Emailed later is fine.
Perfect. Yep. Just speaking to that certificate of compliance, it doesn't actually define an area of where the vegetation clearance is for. It says it applies to the whole site, or applies to the site, and it was submitted in relation to the subdivision as well. So, as soon as the whole site is subject to the subdivision, it stands to reason that the compliance certificate is for the full site.
So, okay, I think I'm clear on where you're coming from. Mr. Dace, do you have any questions?
No, I don't. Thank you.
Mr. Bircher?
Nothing further from me.
Well, I think that's easy. If you could email us a copy of the certificate of compliance, that would to add to our fund of information, which is accumulating by the day.
No, thank you for your work on this, and I'll send that through when I get back to the office.
Okay, perfect. All good. Thank you. Thank you for your time. Boston Real Estate is the last submitter, so we'll adjourn for the day.
Good day.
Thank you, and be back 9 AM tomorrow.